So one of the new topics that General Counsel especially need to be aware of is ICANN's plan to launch new top-level domain names. ICANN is the outfit that runs the domain naming system, and they're in the final stages of policy development to launch essentially new extensions that will be in place of .com. .com's not going away, it's just a new opportunity for additional domain names. And some of those domain names will be brands because it's open to everybody, even brands. So for example, there may be in a few years from now a .coke or a .pepsi. And so these are important branding decisions that are going to affect marketing outcomes and all sorts of things. And there's also a very important legal consequence to all this because essentially your brand will be wrapped into a registry and it will have ramifications in terms of having to deal with ICANN on branding issues and registry issues, and also how you take your message in the new top-level domain name to consumers. There are some things to be concerned about. The first thing to be concerned about is preclusion. Now, ICANN is going to do round one, and they say a year after round one, they're going to try again with round two. But of course, the last time they did a new top-level domain name round, it was 7 or 8 years between that one and the new one. And so, since ICANN's not known for their speed at moving things forward, I don't think anybody can really count on that 1-year window of getting a second chance. The other thing to be concerned about is they're not going to allow top-level domain names that are confusingly similar to each other. And so if you have a brand that's very close to somebody else's brand, even though in your mind the brands are distinct, ICANN, their examination experts may not find them to be very unique from each other. So for example, UPS and UBS are quite close. And it's not very clear at this stage whether or not the ICANN examiners are going to allow those two marks to coexist in a top-level domain name. And so if you share a mark or you share a close mark, that's something to be concerned about. If you share a mark, it's especially something to be concerned about. So I think, of course, the great example of two great companies that share a mark in this country are Delta Faucets and Delta Airlines. And so in that situation, there can only be one .Delta. And so there are issues even before the application process starts about how do we work out coexistence, how do we do those things to make sure that everybody continues to get along and not step on each other's toes. These branding issues are front and center right now. In terms of timing, ICANN can pull the switch at any moment. The last meeting in San Francisco just ended yesterday, and there's another meeting in Singapore in June, but I know that ICANN is anxious to get this done. Once they say yes, the applicant guidebook is ready to go. There'll be a 4-month communication window where they allow people to understand fully what's going on here, and then there'll be a 3-month application window. So we're talking about something that could happen in the next 8 months, and so the planning stages and the budgeting stages really are upon us now. Very exciting in some respects because the internet's expanding. It's a great way for brands to express themselves on the internet. It's very troubling from some aspects because unlike registering a .com through GoDaddy, this is not a $15 deal. This is a big expense. ICANN's application fee alone is $185,000 to do this. So it's not an inexpensive venture, and it also raises all kinds of branding issues and cyber squatting issues and all those sorts of things that general counsels are concerned about. But certainly time right now to become educated about what's going on and to develop your internal plan about how you're going to react to it. Are you going to apply to be a registry, or are you going to take a defensive position and use litigation as the tool to keep anybody too close to you away from your space? Those are all things that need to be sorted out, and the time to start sorting those things out is right now. Well, it's not going to be a horse race because there's an application window, right? And so the window will be a 3-month window, and there is, at least the way the applicant guidebook is written today, there is no benefit on being the first application in. You just have to have it in within the window. So those two applications, if they are for identical mark or for confusingly similar marks, will go into what's known as a contention set. And they will be in contention with each other. Any domain names that are also confusingly similar to them will unfortunately be held up while that contention is resolved. And ultimately, if the contention can't be resolved, then it will go to auction. And so then whoever wants the top-level domain name the most will have to pay ICANN quite a bit of money to outbid the other guy. And so that's how that's going to go. There's also this issue, and to touch on it just briefly, of the community application. And so if someone has a community that they believe that they represent, they can also file for a corresponding top-level domain name, even if it is a brand. And if they qualify under the community analysis, their application could actually trump a brand. So say, for example, somebody puts together a community of people who live in the Mississippi Delta, and they want to be .delta. If they're able to convince ICANN that they in fact represent a community that can be identified, that the overwhelming majority of the community believes they represent them, and they back the application, they could in fact be in a trump position in relationship to the other applications. I use the .delta example of a community application sort of facetiously because there is no, Delta community that I know of, but it's a classic example of a problem that may occur depending on the nature of your mark. I expect of the entire process, because of the trump position, to the extent that there will be gaming, I think it's going to happen at the community-based application level. So there are some nuances to all this. It's not just first to file, and there are some things that need to be done on the front end. So for example, how you set up the company who will serve as the registry is important, because if there's no way to make that a joint venture, if there's no stock sharing, if there's no ability to bring somebody in who otherwise will be locked into an auction with you, then you're in someone has to lose and someone has to win. But if there's a way to use that company structure to make a friend and everybody share a top-level domain name, and you can delineate what you want in the second level, that area on the left-hand side of the dot, you register faucets.delta and I'll register airline.delta, and you register sinks.delta and I'll register tickets.delta. If you can do those things and work out happy compromises, then great. But if you don't do the correct planning up front, it's going to be harder to get there in the event both applications go in.